When is Chapter 11 the right decision for a shipping company?
It's an excellent question. We've gotten the calls from a number of shipping companies saying, hey, I hear Chapter 11 is a good option for us. And our answer is, it's the last option for you. If you can't do anything out of court, if you're facing potential arrests, or if your cash is going to be frozen, then yes, Chapter 11 gives you the best chance to reorganize on an in-court basis. But it is an emergency room. It is not a health spa. And so you should figure out what else you can do, if at all possible, before then going the Chapter 11 option.
Your firm has been involved in a couple of very notable maritime bankruptcies recently, Omega Navigation Enterprises and Marco Polo Sea Trade. What have you learned from those two cases? What went right for you guys and what went wrong?
Well, I think what those cases did for us is they reaffirmed what we've long known, which is preparation and planning are two keys to success. You need to enter Chapter 11 smoothly and seamlessly. In Marco Polo, we were not able to do that just due to the circumstances of our client where vessels were arrested and cash had been seized. Tried the best way to get out of bankruptcy is to have a plan when you go in. We have not had that opportunity in those two cases, but we are involved in other situations where we have much more lead time in order to prepare, in order to work with the lenders and the constituents to narrow down issues. So if there's a Chapter 11, it's a much more methodical and pre-planned event.
Emotions can run pretty high in these bankruptcy situations, particularly when you're dealing with banks, lenders. What advice would you have for a ship owner that was in a Chapter 11 situation in how best to handle the situation and the relations with lenders that may not be on board with, let's say, an initial plan of restructuring that's filed with the court?
Given that so many ship-owning companies, even the large public ones, have a family or an individual behind it, much of the negotiations can end up being more personal. Bank lender to ship owner. Our advice in those circumstances is let the professionals get in the middle. This is what we do for a living. They will have professionals on their side. We can assess what makes sense economically and financially, and we can talk to you, the owner, about what we think is appropriate and realistic, what will move the needle. If you get involved in the negotiations directly, however, then the fact that you built this company from scratch can't help but get in the way of figuring out what is the best solution for everyone.
We've heard from a couple of delegates who have mentioned that lack of understanding about the Chapter 11 process, particularly when you're talking about counterparties in Asia. The lack of understanding can create an issue, particularly when you have an owner that may want to get chartering business with a company in Asia, may not understand the process. Is that a risk of the bankruptcy, the Chapter 11 process, the stigma attached?
We have seen situations where it becomes a negative for the company when they're either threatening Chapter 11, rumored to be going in, or actually do go in. We are finding a little bit more now that there has been some experience that ship owners or counterparties, whatever they may be, are able to hire U.S. counsel, get a better explanation, and take part in these in a manner that allows them to protect whatever their interests are. So I think it may be indicative of the fact that, again, that Chapter 11 is being recognized as probably the best way for a ship owner to reorganize when everything else seems to be failing. And so everybody that's involved in that process is becoming a little more sophisticated because they have to, but it makes good sense for them to be well advised.
We've seen some high-profile bankruptcies involving publicly traded shipping companies, companies that issue debt and have to deal with negotiations with bondholders while in court. Can you talk a little bit about your experiences in that process, and maybe offer some advice on how to best handle negotiations with bondholders?
When you're dealing with bondholders, you're not so much in the world of maritime anymore. You're in the world of distressed debt. They look at a piece of paper, whether it's a bond issued by a shipping company or by a manufacturing company, as an economic unit. And their intention is to increase the value of that unit and then sell, or to protect against a decrease in the value of that unit. So you need to focus on it from their perspective. How do you increase the economics? Much less so than what is right for a shipping company versus a company in another industry. With the lenders, of course, it's very different. They are ship lenders. For them, the maritime is everything, as it is for the owners. So understanding the different dynamics of the different parties is key to reaching a consensual resolution in the end.
Do you guys expect to see more Chapter 11 bankruptcy filings in the near future?
I do think there's a possibility that we will see additional shipping companies coming to the United States to seek Chapter 11 protection. I think the difference that you'll see is they'll be more planned, more methodical, and I think that will lead to increased likelihood of a very successful workout.